This is a shortened version of a Toolbox Talks training session. The aim is to focus on the key issues relating to data security and protection in community pharmacies and stimulate discussion using real-life examples. The session includes a brief refresher on the background and importance of general data protection regulation, with a summary of how the pharmacy manages this, followed by a summary of key issues and a discussion using some real-life examples. The pharmacy has a hard copy and online folder containing all relevant information, including how to access further information and support. Here's a list of the legal requirements for data protection. For pharmacies, this is relatively straightforward, and it's summarised in the Pharmacy Privacy Notice. Any information collected must be collected for a specific purpose and can only be used for that purpose. The data subjects, that's the patients, have the right to access this data and to ask for it to be amended if it's incorrect. This information must also only be retained for an appropriate amount of time, and specific rules apply to healthcare data retention in the UK. In addition, care providers, including pharmacies, have a responsibility to ensure the data is kept safe, the system used to store the data and share the data comply with data protection law, that any incident and near misses are reported and acted on, and that they have the relevant structure in place to ensure all this happens. General Data Protection Regulation, GDPR, which is enshrined in UK data protection law, specifies that those involved are categorised as either controllers or processors. Companies who provide the pharmacy management systems, EMR systems, and care home systems are data processors. Pharmacies are data controllers, meaning that they are the main decision makers and have control over the purpose and processing of the data. There may be circumstances, for example with EMR systems, where there are joint controllers. An example of this would be where both the pharmacy and the care home can access and enter data or change data on the system. If this is the case, it's important that the pharmacy and the care home understand that they are joint controllers and that they need to agree jointly on any changes to the system. The Data Protection Officer will be able to advise on this if there are any questions. Each year, the pharmacy completes the NHS Data Security and Protection Toolkit. This asks for the major risk areas to be identified. The pharmacies that we work with have identified the following 3 areas as the most important. Number 1, loss of access to systems. Number 2, unauthorised access to systems. Number 3, prevention of cybercrime. As a result of this, the pharmacy has updated its SOP on business continuity, and the training emphasises the need to prevent unauthorised access to systems and to be alert for cybercrime and scams, which can come in by email, texts, WhatsApp messages, phone calls, etc. It's important that all staff are familiar with the Information Governance Policy and Standard Operating Procedures. These can be found in the Information Governance folder and online. The Business Continuity Plan is particularly important because while the other SOPs detail activities which happen daily, the Business Continuity Plan, SOP number 1, lists what to do if there is a systems or power failure or anything else that could severely affect the activities of the pharmacy. So it's a useful reference document. In the Toolbox talk, we looked at 3 reflective questions. I'll briefly mention them here. Question number 1. A patient's relative calls the pharmacy asking for a list of their relative's medicines. They tell you that their relative has just been admitted to hospital and the care home has not sent an up-to-date list of medicines to the hospital. What do? We discussed that providing this information is the responsibility of the care home, and that anybody providing this information needs to be sure that they are talking to somebody who's authorised to represent the patients. That is, that they've got a lasting power of attorney, LPA, or a court of protection deputyship. If this problem is not solved by the care home providing information, this is something that should be escalated to the Data Protection Officer. If, after thorough investigation, it was considered appropriate for the pharmacy to provide this information, This would need to be well documented and the rationale for doing it included in the documentation. This is an example of where things are not always straightforward and where acting in the patient's best interest may override the normal course of action. I asked this question after reading about a patient in hospital whose relatives knew that the medication list provided by the GP surgery wasn't up to date, and the patient was harmed because vital medication was not given. In this case, it was medicine for Parkinson's disease. This was investigated by the Health Service Safety Investigation Body. I've included a reference to this in the video description. Another question involves the situation where a new computer system, which looks very good, is demonstrated to the pharmacy. Adopting this system would be a decision for the pharmacy directors, involving the data protection officer, who will carry out a data protection impact assessment. The key learning point here is that any new systems must comply with data protection laws and regulations. These systems must be supplied by a company that has the relevant accreditations. These include, as a minimum, number one, being registered with the Information Commissioner. Number two, being registered with the NHS Organisational Data Service. This can be checked online through an NHS ODS code search. And number three, having successfully completed the latest NHS Data Security and Protection Toolkit, which again can be checked online. In addition, ideally, these suppliers should have evidence of having carried out a data protection impact assessment on their system and have a named data protection officer. The third question concerns if an email is inadvertently sent to all care homes and it contains a list of patients and patient information. What steps would the pharmacy need to take? This would need to be raised as an incident following the procedures set out on the incident template. The priority would be to assess the impact and any potential risks and to manage these. This will include assessing whether the data is personal data or special category data, that is, health data. The definitions here are personal data, means names, addresses, email addresses, NHS numbers, etc. Special category data, which is health data, requires a higher level of protection and its processing is subject to stricter conditions. If this information has been sent to anyone who is not a healthcare professional or may have been shared more widely, the data subjects, that's the patient, whose information was inadvertently shared, need to be informed. The data protection officer will advise on what needs to be done and support the process, including liaison with the Information Commissioner. Here is the summary produced in January 2025, which shows situations where the Information Commissioner has taken action. In these cases, the Information Commissioner reprimanded the organisations concerned. The areas where action was taken included poor handling of sensitive data, unacceptable delays in processing which resulted in referrals getting lost, insecure storage of records, particularly on memory sticks which were not encrypted, data deleted which should have been retained, personal data shared in error through CCing an email instead of blind copying it, for example, personal sensitive data shared using personal email addresses instead of using the work email address, storage of information in more than one place where people were not authorized to have access to see it. This data was also retained when it should have been deleted. Thank you for listening. If you have any queries or comments, you can email me at the email address shown on the screen.